The next thing that happens is they are returned to custody, and hopefully they can bond out or a loved one can bond them out. And they then can request, whether they're in custody or out, they can request a preliminary hearing. Now, what is a preliminary hearing? A preliminary hearing is exactly that. It's a hearing and it's preliminary. It means it's at an early stage. And at this preliminary hearing, the state does have a burden of proof. It's different than the burden of proof you find at trial, which is in the post-indictment phase, right? So it is going to be something that you see as a lower, easier standard for them to reach. Now, that standard is just probable cause. It's the same standard that a judge used when issuing the arrest warrant on the felony or any search warrant on the felony. It's also the standard that the officer used when the officer made the arrest to start this whole process. So all that has to happen at a preliminary hearing is the state has to put on evidence, and that's usually just testimony, and it's usually testimony from the detective who's working the case. Sometimes it's not the detective. They'll just send in some other law enforcement officer to literally read from the detective's report. I've seen that too. Again, all they have to do is hit that low bar of probable cause. So you may say, well, if there's already been a probable cause determination by a judge a couple of times along the way here, what's the point? Well, sometimes we can get involved and we can show the judge at this point that there's not probable cause, because up until this stage, nobody has argued that there wasn't probable cause. It's been a prosecutor or it's been law enforcement saying, Judge, there's probable cause and here's why. Okay, so we can get in there and sometimes show the judge and convince the judge there's not probable cause. If we can't do that, then there are still two other things that hopefully we can accomplish. Again, all of this depends on the facts of each individual case now. Bear that in mind. But the first other thing that we can do is learn about the case, right? Because this is the only time we're going to get under our rules before an indictment comes down, and really before trial, usually, or before a motion to suppress. It's the only time we're going to get any testimony under oath from a law enforcement officer about a particular case. So it's very important to be able to have this. It locks people into their testimony, and it gives the defense a peek into what's going on. And otherwise, we're not entitled to it under our rules. Again, when I say our rules, I mean the Mississippi Rules of Criminal Procedure. Under our rules, we're not entitled to much at all from the state at these early stages in this first phase. Okay, so it's important to get that information that we can during the preliminary hearing. The other thing we can do at a prelim is we can hopefully get the judge to reduce any bond if the person's still in custody to a bond that they can make. And if we can't do that, if they're out already, maybe there are some conditions on bond that we can have lifted at the preliminary hearing.